Okay, we're on the record.
Thank you very much. Good morning. Welcome to the Massachusetts Appeals Court, sitting by Zoom on this Tuesday, March 26, 2024. I am Justice Joseph Ditkoff. I was the single justice that was assigned to this case, which was done by which month it came in. I will call the only case that we're hearing today on Zoom, which is Gaskins versus Hollomon, number 24J86. In front of me is a motion to stay a preliminary injunction. The preliminary injunction itself has been appealed to a panel. That is not what I'm here for. I'm just here to decide whether to stay it pending that panel decision. Mr. Woolley, it is your motion. So we will hear from you first. Unless anyone has anything anyone have any issues before we start? Everyone hearing me okay?
Yes, Your Honor, we hear you good. I hear you good.
Mr. Yardi, can you hear me?
I can hear you to a sufficient extent, but they tried to fix it, but it's not. That's the best it can do.
All right, but you can, if you're having trouble hearing, say what Mr. Woolley's saying, raise your hand and we'll deal with it, okay?
Okay.
I'm sorry, one of Mr. Williams, Mr. Gaskins told me they could hear me now. I've already forgotten who.
I'm Mr. Williams right here.
And you can hear me, Mr. Williams?
Yes.
And Mr. Gaskins?
Yes, sir. Yes, Your Honor.
If there's any problems with that during the hearing, just raise your hand. I'll try to keep an eye out and we'll
No problem. Thank you.
Okay. All right, Mr. Woolley, you're up.
Good morning, Your Honor, and may it please the court. Timothy Woolley for the defendant's appellants. The question before the court today is whether Your Honor should issue a temporary stay of the Superior Court's February 8th and February 10th orders, which are overly broad and dangerous until it's such time that the appeals court's full panel can hear an appeal of those orders. The answer to that question is a clear yes, and it is largely because defendants' appellants satisfy all requirements of a temporary stay pending appeal of this matter. First and foremost, most significantly, is that defendants' appellants will face significant and irreparable harm should this court deny defendant's motion. And as laid out further in the papers, the chief and foremost harm there is the severe risk to safety and security in department facilities that will result from compliance with Judge Frazon's orders.
Let me direct you a little. I got the sense that once this started, you started holding hearings, 90-day hearings. You said
That's correct, Your Honor.
4 to 6 weeks. It's been 6 weeks now. Could you update me on the status of those hearings?
Absolutely, Your Honor. That 4 to 6 weeks was the initial estimate. As of yesterday morning, the department has completed 57 of those 90 hearings that were initially identified, and is continuing to conduct those hearings as we go along. Shortages in departmental staff, as well as other needs within the facility, certainly can cause delay or can cause essentially delay in getting those hearings done. But since Your Honors, or since the Superior Court orders were issued, we have conducted 57 hearings. As of yesterday morning, I expect more were conducted yesterday, although I don't have those numbers before me at this time, Your Honor.
And can you walk me through what these hearings are like? Are these full chance hearings?
Your Honor, they are. They're the 90-day placement reviews that are set forth. I believe the CMR is 423.09. And those are the three-person panels that consist of correctional staff or programming staff, security staff, and additional administrative staff. So it is a three-person panel that the individual appears before. And those have been each facility with a BAU and or SAU has been conducting those hearings since the Superior Court has issued their orders.
And the inmate in question is given an opportunity to appear personally if they want to?
That's correct, Your Honor. The inmate is provided, per la chance, the inmate is provided notice of the hearing, an opportunity to appear in person at the hearing, and then an opportunity, and to contest the reasons for which they are housed in the specific unit that they are housed in, and then they receive written notice of of the board's decision.
If I stay this, will you continue doing those hearings? Do I need to make some direction in that regard?
Your Honor,
What's the DOC's thinking?
the department requests that if a stay is issued, that Your Honor permit the DOC to stay these 90-day hearings. It's the department's position that this is really duplicative work that is being done. As laid out more fully in the papers, individuals in the BAU already have the 60-day appraisals, and that already takes a significant amount of staff resources to conduct. Those involve a meeting with the correctional program officer, and then a three-person panel meets outside the presence of the incarcerated individual to discuss their rationale. For those appraisals, the incarcerated individual is similarly given notice of the reason that they're being held in a BAU, and they are offered an opportunity to provide both verbal feedback to the CPO that they meet with, as well as written feedback to be considered by the three-person committee. So
Well,
essentially,
let me ask you something about that. I saw that the policy says it will normally be facilitated by a correctional program officer. How normally is that? Because how
Your
often
Honor,
is
I am
it?
not personally aware of any instances of this occurring outside, being conducted by someone other than a correctional program officer, although that is certainly information that I'm happy to obtain and submit as a supplemental filing for the court if Your Honor would like. But my understanding is that this is almost always done by a correctional program officer. As noted in our supplemental record appendix, the department is currently experiencing a significant shortage of both correction officers and correctional program officers. And that certainly may impact that, although I am not aware of any impact that has had with respect to CPOs conducting the 60-day appraisals in BAUs.
Let me ask you this about the 90-day hearings. Once you get through the backlog, do you think you have enough staff to keep them going each 90 days after that, or is that not possible with your current staffing situation?
That is something that I would certainly need to consult department staff with, Your Honor. But I do know, based on conversations with department staff, that the current system that we are employing following the Superior Court orders, the 90-day reviews, as well as the 60-day appraisals, which are required under CMR 427, 103 CMR 427, has been incredibly operationally taxing on staff. And even once we get through that backlog, I expect that it still would be operationally taxing to conduct both the 60-day appraisals and the 90-day reviews. However, given the conditions of confinement in department BAUs, those 60-day appraisals are a sufficient level of due process to ensure that incarcerated individuals are heard, are notified of the reason that they're being held in a BAU, and to be considered for either retention or for movement out of a BAU. Is the department's position that is a sufficient level of due process, and essentially we're going through a duplicated effort to attempt to ensure compliance with the Superior Court orders. But again, that has been duplicative and extremely operationally taxing.
Do you believe that the 60-day appraisals are consistent with LaChance, or are you saying that because of what the BAUs are, they don't need quite as much process as LaChance requires?
Your Honor, with respect to LaChance, excuse me, just give me one more second. The only way that the 60-day appraisals differ from LaChance is that from the 90-day placement reviews that were implemented in response to LaChance, is that the incarcerated individual does not appear before the three-person board.
Before you get to that, let me explore that a little bit, because at least from what I'm seeing in the policy, maybe I don't understand the 60-day appraisal. It doesn't seem to have the description of the evidence relied upon and a description of expectations to be given afterwards. Those are things that the sort of regulatory LaChance hearings have that the policy doesn't seem to have for the 60 days. Am I wrong on that?
Sorry, I apologize, Your Honor. Can you just repeat those?
So one of the things that the regulatory LaChance hearings have
Mhm.
is they have a description of the evidence that was relied on, and then afterwards, if there's no reclassification, description of expectations and how the inmate can do better next time. And I didn't see that in the BAU 60-day policy, but maybe I'm not understanding.
Certainly, Your Honor. I mean, that is covered within the initial appraisal. Incarcerated individuals are provided notice of the reason that they're being held within a BAU, and they may provide response to that. And then that is, essentially that reason does not change why they're being held in the behavioral assessment unit, and would apply to subsequent 60-day appraisals. Moreover, that is certainly information that can be discussed between incarcerated individuals and the correctional program officer during the subsequent appraisal process, why they're being held there. And if sort of on a parallel track, if that reason relates to a disciplinary offense or the resolution of a disciplinary offense, then the incarcerated individual is separately afforded another level and separate level of due process through the department's disciplinary policy to challenge that disciplinary ticket. So there would also be due process afforded in that regard as well for them to challenge the reason that they're being temporarily detained or held in a BAU to resolve that disciplinary report. With respect to the department's position on LaChance, it is the department's position that the level of hearing and due process required by chance really does not apply to department BAUs, because department BAUs by statutory definition are not restrictive housing. And the conditions of confinement in department BAUs are drastically different than those that existed in the former department SMUs that were at issue in the LaChance matter. And in similar cases, I know the Perry case was submitted by plaintiffs' appellees to Your Honor as well. The conditions of confinement are really drastically different in those cases from the present case, Your Honor.
If we explore that a little, the Hollomon affidavit says that inmates in the BAU get 1.5 hours minimum outdoor recreation time, 1.5 indoor recreation time, but the inmates suggest that time is actually in cells, just different cells, indoor or outdoor. If you could enlighten me on that. I didn't really see anything in your evidence about the nature of that recreation time.
Certainly, Your Honor. The recreation areas are individual fenced-in areas, outdoors, under cover. And I would just note that the Criminal Justice Reform Act makes reference to Department of Public Health standards. Those can be found in 105 CMR 451. And that provides a definition of a cell. Those standards provide a definition of a cell that's at 451.020. A cell is defined as any room or group of rooms within a correctional facility used or intended to be used by a prisoner for living and sleeping. And then the Department of Public Health also sets forth a separate definition of a recreation area.
Wait. Can you just give me that site again?
Absolutely. The site for the definition of a cell is 105 CMR 451.020.
Okay.
And further in that same CMR 451.213 is a separately defined recreation area. And the fenced-in recreation areas outside that individuals are brought to for at least an hour and a half a day fall within the space requirements of that DPH definition. Furthermore, Your Honor, I would note, although it has not been fully briefed on, it's the department's position that the CJRA was largely implemented to limit and mitigate the mental and emotional impact that isolation or solitary confinement may have upon an incarcerated individual. And that was certainly why the definition of restrictive housing of 22 or more hours in a cell a day was implemented. Now, the outdoor recreation area is far different from the indoor cell areas that are contained within department BAUs and SMUs. The outdoor recreation areas are separated by a normal type chain link fence or similar. And incarcerated individuals have the ability to socialize with one another while they're out there, engage in group physical exercise together. So really, the outdoor recreation area.
Let me make sure I understand what you're saying, is that
Certainly.
outdoor recreation area, the inmates can't touch each other, but they can talk to each other and interact non-physically.
Precisely, Your Honor.
Okay. And what about the indoor recreation?
Indoor recreation area can vary by facility, but it is still at least an hour and a half in each unit, and generally looks essentially what's called quote unquote table time. Individuals will have one restraint, one arm restrained to a metal table that's in sort of the kind of lobby or atrium or whatever area you want to call it outside of the actual cells. And they'll be placed at those tables where they can interact and socialize with other individuals. Depending on the facility, the games, cards, etc., may be made available to those individuals. The restraint to a table with one hand is done for security reasons. In certain units, individuals are off restraint status and may be unrestrained when outside of their cells. However, for safety reasons, if one individual is restrained to a table, then all individuals must be, just to essentially assure that we don't have a situation where an unrestrained inmate is assaulting a restrained inmate. And that would be the logic behind that. But there are varying degrees of unrestrained status outside of cells, depending on the unit that the individual has been in, depending on the phase of the unit that individual is in. And again, just going back to the statutory definition, we have these 3 hours out of cell a day, at least an hour and a half outdoor, hour and a half indoor. And that time is not inclusive for additional time out of cell for showers, for programming, for non-contact visitation, and similar reasons for out of cell movement there, Your Honor. So it really is a drastic difference from what the legislature intended when they defined this bright line rule of 22 or more hours a day in a cell, and therefore the restrictive housing case law and statutes really do not apply in this instance. With respect to the whether or not any harm will come to plaintiffs should Your Honor not allow this order, there really, as discussed in the papers, there really will be no harm in this instance that'll come to plaintiffs because two of the three have already been moved out of the Concord BAU. And my understanding, which again I can file supplementally with the court, is that Mr. Gaskins will have a reclassification hearing tomorrow after his pending disciplinary report has resolved, or it has since resolved, and he will be reclassified and expected to be moved out of the Concord BAU.
So that hearing tomorrow would be a full chance hearing?
Not a LaChance hearing, Your Honor. It's a reclassification hearing, which is under CMR, I believe it is 420, the department's reclassification policy. Incarcerated individuals are guaranteed a reclassification review at least once a year, if not more often. And during that reclassification review, that's what uses the objective point-based score to determine the appropriate security level, and determine the appropriate facility and unit that individual should be incarcerated to or housed at. Again, that is, although it's different a different policy from the 90-day reviews, excuse me. It similarly has a 3-person review board, where the incarcerated individual is being considered for a transfer to higher or lower or even laterally to a different facility. Then that person is permitted to appear before the board. And where in instances where the individual is being considered for reclassification to higher custody, that individual is permitted legal representation at the hearing. And I do believe Mr. Gaskins can correct me if I'm mistaken, but I believe that Mr. Gaskins will have legal representation at his reclassification hearing tomorrow.
What was the nature of the February 12th hearing that Mr. Gaskins got?
The February 12th hearing was the 90-day review pursuant to CMR 423.09. And those were the 90-day reviews that were implemented, the department policy that was implemented in response to LaChance. However, the 423 policy is not what governs here. It's the 427 policy. And that's really based on the conditions of confinement not being restrictive housing. Effectively, 423 is the former restrictive housing policy within the department. However, the department effectively no longer uses that policy, as it no longer has restrictive housing units that are, statutorily defined. It created the 427 policy in response to the implementation of the CJRA. But the 423 policy remains on the books, although normally it is no longer used following passage of the CJRA and the department's response to the CJRA. Although it obviously has been being used since the February 8th order of the Superior Court.
All right, so I certainly will expect you to tell me what the results of Mr. Gaskins' hearing are
Certainly, Your Honor.
as soon as you can. I saw the trial court judge issued a stay of proceedings, but I couldn't tell which judge it was. Do you know?
That was just Judge Christopher Barry Smith, I believe that's the correct hyphenation or order of hyphenation.
That's his name, if that was the judge. Just finally, there really hasn't been much discussion of the conditions in the BAU, which was the initial complaint, not really what Judge Friesen focused on. I don't know if there's anything you want to say about that.
Yes, Your Honor. Just with respect to the conditions of the BAU, there certainly, I certainly recognize that there seems to be a dispute between the department and plaintiffs as to the actual conditions of confinement in the BAU, not necessarily what the stated conditions of confinement are per the 427 policy. The department certainly stands by Defendant Hollomon's, Deputy Superintendent Hollomon's sworn affidavit that those are in fact the conditions of the BAU at MCI Concord. And further, with respect to the papers, at the very least, if there is such a factual dispute, that the Superior Court at the very minimum should hold an evidentiary hearing. Again, as we noted, the Superior Court made no reference to Deputy Superintendent Hollomon's affidavit in their orders, and there were similarly no findings of fact to support the Superior Court's legal conclusions in this instance, which has really left the department a bit perplexed as to how to comply with the orders, as the orders reference units that don't even exist in the department, and further use the term segregation, quote unquote segregation, which could apply to many units, including health services units, severe mental illness units, and the like. So despite the department's request for clarification to the Superior Court, it's the department's position that we did not receive any clarification with respect to that order. Now, again, with respect to conditions of confinement, I would just briefly summarize what we have laid out in our papers, and that the current conditions of confinement in the BAU are substantially different than the prior restrictive housing units, special management units, and the like that were at issue in LaChance and Perry and similar cases. To point the court's attention to the LaChance case, in that case, the individual was provided 5 hours a week of outdoor recreation, and there's no mention of any indoor recreation time in that case. If you compare that 5 hours of recreation time, in that case, the individuals currently in the BAU get 10.5 hours a week of outdoor recreation and 10.5 hours a week of indoor recreation, a total of 21 hours of indoor and outdoor recreation per week, which is more than quadruple, which that was at issue in LaChance. And again, just to reiterate, that time, those 21 hours do not include time out of cell for showers, for programming, for non-contact visits, and the like. There are additional non-contact visits allowed. There's one additional non-contact visit allowed per week in the present conditions of confinement as compared to LaChance. LaChance allowed 2 non-contact visits per week. Current BAU regulations, the 427 regulation, permits 3 non-contact visits per week. The current canteen in the BAU and SAUs is more expansive than what was at issue in LaChance, and the amount of money that incarcerated individuals may spend per week is also increased compared to LaChance. In LaChance, there was absolutely no permission for incarcerated individuals to participate in educational, religious, vocational, or rehabilitative programming. That is permitted under the 427 policy in this case. Moreover, I will note to your honors that since LaChance, the department has since issued or started the tablet program, and all incarcerated individuals have an electronic tablet, unless there's some security concern or some significant security concern or reason that they may not have it in their cells. But otherwise, these individuals all have these electronic tablets in their cell. The electronic tablets have access to free educational programming, as well as other programming options. And there's also an opportunity through the canteen to pay for entertainment options on those tablets, which is a significant difference from the LaChance case. Again, just a few more things. A few more differences with the current conditions of confinement. In LaChance, there's no mention of the incarcerated individuals being permitted phone calls.
That's enough LaChance.
Understood, Your Honor.
You've been at it 26 minutes. Anything final you want to say?
Nothing final, Your Honor, other than to say that the department has established that it satisfies all the criteria for really just a temporary stay of the order, until the full panel can hear the orders. And Your Honors do ask for a stay and some sort of relief so that the department no longer has to afford these duplicative 60-day appraisals and 90-day reviews, just to limit the operational tax upon the department. But other than that, the department and defendants appellants will rest on their papers, Your Honor.
All right, thank you very much. We will, inmates will go alphabetically, so we'll start with Mr. Gaskins.
Okay, Your Honor. All right, the first thing is this. We're dealing with non-disciplined prisoners. That's what this whole thing is about. Non-disciplinary. This thing has been established since Chapter 777 in 1957 that was enacted through the government and first formulated in the decision of Blaney versus Commissioner, which out of came 127, General Law Chapter 127, Section 39, and General Law Chapter 127, Section 32, which was used in the Blaney case to determine how non-disciplined prisoners are to be dealt with in the state of Massachusetts. Out of that evolved the Hartford case, which established the 421s. All right. Out of the 421s, was the uniform standard of how segregation was conducted in the state of Massachusetts until the DOC starts trying to figure out ways how to circumvent that law and policy and regulations. So this is how segregation consisted of back in the 1980s up until the early 2000s. Every single segregation, you had your television, you had all your property that was in general population inside your cell in segregation. You had contact visits, you had access to programming, access to religious facilities. You had the same access to the phone rights and privileges as every general population prisoner. So therefore, you could use the phone every day. In the same token, when you came out your cells, you wasn't put in a cage. You was put in a recreation area, and how it was set up was a fenced-in area. You had a basketball court. You had a handball wall on the side. You didn't come out in handcuffs. You walked out. Individual cells would open up, and the people walked out to the yard and went to the prospective sides that they wanted to recreate on, where they had physical interaction with one another. And the reason why this was allowed, Your Honor, is because these were non-disciplined prisoners. They was administratively segregated. So they was isolated from populations, but inside segregation, they was allowed the full benefits, privileges, and rights as if they was in general population, just in a restrictive environment. That's what that was. All right. So then we fast forward to what the DOC started figuring out in the SMUs when they created the first SMU was created in 1992, and it only existed one SMU, and that was in Shirley Median. All the other segregations in the state of Massachusetts ran under the 421s, which came out of the Hartford decision under judgment order number 11. And so what the DOC figured out was saying, okay, well, what we will do to circumvent the 421s, we will call all segregations SMUs. And that's when they became special management units. So in the caveat in the SMUs at that time was they had the option to give you the television or the radio, but you got everything else, contact visits and everything else. All right. So then what happened was they figured out, well, we don't want guys to have their TV, so we'll just take that. And so we got the discretion to do that because of the oral language within the statute, within the regulations, excuse me. So I challenged this because I said, no, we got a right to have our canteen and all that, when the DOC was saying, no, we got the discretion to give you the canteen and take it from you. So when I challenged this, I challenged it under Foxworth versus Maloney in the early 2000s. It was before Judge Margot Botsford. This when she was still the Superior Court judge. She ruled in our favor. And she said, so since they said the 423s only applied and the 421s didn't apply, so I challenged it under the 423s. And I said the 423s was very, very clear in its mandated language that we're entitled to this canteen and the TVs. So she agreed. She said, so the DOC forthwith ordered to give all prisoners in 10 block and segregation the canteen and the televisions. The DOC, when we came back and asked for our stuff, the DOC went into emergency session and changed the 423s in the early 2000s and took out the TVs, they took out the canteen, and then said, now we ain't got to give it to you. So although the judge ordered this, we ain't got to give it to you now, and didn't give anybody anything. So so because all SMUs fell up under that, and the 421s was basically pushed aside, which still had an impact, but it wasn't allowed to have its impact because the 423 circumvented that. And the DOC understood what they was doing. So this went on all the way up to 2018. And although through these years, we had the Haverty decision that came down in 2002 that set the foundation on how the 127 section 32 is applied to non-disciplined prisoners. And then in 2012, we had the Chance decision that came down to deal with non-disciplined prisoners, but it was dealing with it only from a procedural aspect. And it dealt with what do you do with this guy that's sitting here for 10 months? Well, they finally made a baseline in the Chance. The baseline in the Chance was, we ain't gonna allow you to sit a prisoner in segregation no longer than 90 days. So within that 90-day period, he better have a hearing. If not, you gotta release him. So that was the procedural aspect of the Chance. They didn't deal with the substantive aspect of the actual 421s, but they dealt with the procedural aspect of it. However, it set the baseline for how long a person to sit in restrictive confinement. So no matter what name or spin or you put on a segregation unit, it's still isolation, it's still segregated, it's still solitary confinement. That's what the BAU is. Now, fast forward to 2018, because of all the stuff that's been going on and with the recent decision in Cantel, which ordered that the DOC was supposed to come in compliance with the 421s in 2016. What happened was the DOC settled with the defendants in that, the plaintiffs in that case, and didn't have to go into full compliance to the 421s. Although the court said they was to comply with it, they didn't make it a mandate in Cantel, but they said that they should comply with this. So it was up to the Cantel plaintiffs to enforce that through the lower courts, but they settled. So here we come in 2018 with the CJRA that was supposed to close this loophole once and for all. All right. So the DOC, understanding what this man just submitted on the record to this court, is that they understood what the CJRA required of the DOC and that they deliberately and intentionally found a way to get around it. And how they did it, soon as in December the 31st of 2018, when that bill was signed into law, it became effective immediately. So on January 1st, 2019, all segregation units in the Department of Corrections was considered restrictive housing units. And it fell under 127 section 39, which was amended. So it repealed the old 127 section 39, which only dealt strictly with long-term segregation. And it repealed General Law chapter 127 section 40, and then coincided it into the 127-39 under the CJRA, which now restricted discipline to only 15 days maximum. All right. So the DOC understood all this. So they said, well, we're going to find a way to get around it. And this is what they did. So we're not going to call the restricted housing units, although we're mandated to do that under the legislature's intent. We're going to find a way to circumvent it. We're going to name it a BAU, and we're going to put another structured environment called an SAU, and we're going to create a policy, which is not a regulation. See, under legislative intent, under the CJRA, they said, out of that, you create a regulation setting up the RHU units. So the DOC set up the regulations, but they never let anybody know about it, because I just found out about 423s here in the year 2023 and 2024, although this thing was enacted back in 2019. All right. And what they did was, well, we don't have to use it as he just submitted on this record, because BAU ain't a restrictive housing unit. So he goes to Patrice Hollomon's affidavit, which is an Ipsy Dixit and bad faith made affidavit. It definitely is bad faith, because she is absolutely being disingenuous and outright lying to the courts, saying that segregation doesn't exist, awaiting action doesn't exist, although everybody that's put down there is awaiting some type of disciplinary action or waiting some type of investigatory purposes. All right. So he says a policy is not regulation. 427, 103 CM DOC 427 is not a regulation. 103 CM 423 is a regulation that comes out of the CJRA. So here we go again, back to the early to the 90s and to the 2000s again, where they're trying to get around applying the procedural protections, John.
Mr. Gaskins, let me just ask you.
Yes.
What in the Hollomon affidavit is factually wrong? I understand it's just, in your view, is wrong, but what in it is factually wrong?
Here's what she's factually wrong about. She's saying, we're not in segregation. She said, I'm not on awaiting action. She said it doesn't exist. She said segregation and awaiting action doesn't exist. And that's just false. That's outright false. There's nothing where she's not being false about in that particular saying in her wording in the affidavit. Then in another aspect of it, she says that we're entitled to 3 visits a week. We're not getting 3 visits a week. We're only getting 2 visits a week. And if you look at the video, so-called video visits, it's actually a FaceTime phone call. It's a 20-minute phone call. How we get onto that phone, that video, so-called video visit, we got to use our phone PIN number to get into it, and it's a phone call. All it is, but it's almost like a FaceTime, and we got 20 minutes, and we only get to use the phone 4 times we only get 4 phone calls a week for 3 different, we only can use it on 3 different days, all right? And if the phone call drops, all right, and we're restricted to these 4 phone calls, we can't call past that. So even if we get the phone after our 4th call, we can't use it until they reset it on Sundays, all right? So it resets on Sunday. And if the phone call drops, that counts as a phone call. I can't get that call reset. So I could be 5 minutes into the call and it drops. And I say, well, listen, I only had 5 minutes on the phone call, and right to people who oversees this, they say, no, we're not resetting the call. So this is it. So these are the restrictive conditions that we're up under. As for the canteen purposes, when you look at how 421 says we're supposed to get the same as general population, and this been since the 80s, all right, which is still in effect today, as Canto made it very clear that the 421 is still in effect for anybody in segregation. And then 127, section 39, here's where she's being disingenuous, because she's making it appear like, oh, well, we're letting them spend $25 or whatever it is they're letting them spend. But here is what you're allowed to purchase. You're allowed to purchase only 1 bar of soap, 1 lotion, 1 deodorant, 1 book of stamps, all right, 1 writing pad, 1 little 1.5 ounce bag of Cheez-Its, a 1.5 ounce bag of shebangs, a box of unsalted crackers, a bag of coffee, a creamer, and 1 bag of popcorn, a 5-ounce bag of popcorn. This is the food that we're getting in segregation. And they said that this is an expansion. So
could you give me a sense of what it's like and what the purchase limitations are in general?
what the purchase limitation? Well, the purchase limitation is about $7 worth of food, right? This is all we get, $7 worth of food and 1 item.
When people are in general population, what do they get?
Oh, they get $85 in purchase a canteen, and they get to purchase everything that's on the thing, that's on the list in the canteen. And the reason why there's no reason why we can't get it, because the canteen switched over in the 90s to make it more conducive to where the canteen could be sent to any part of the prisons. Because back in the 80s, they used to have canned goods, can openers, and all that stuff. So segregation went, only thing you couldn't get in segregation back then was canned goods. You couldn't get anything canned goods, but you could get everything else. So what the DOC went to was later on in the 90s was the pouches. So these are more friendly. There was no can, nothing you could use a weapon, stuff like that. So everything that they sell us can be provided to us in segregation. Everything that they sell out in general population. So in general population, they get an $85 purchase out there in this general population. In segregation, we get $25 worth and only $7 worth of food and only cosmetics, which 1 item. We can't order 2 bars of the same soap. We can't order 2 lotions if we need it. They allow us only 1 toothpaste, which is a very, very cheap generic brand that they sell you. They won't sell you none of the good brands, although in population, they sell you the better brands, right? So these are what we're receiving from the canteen aspect of it. All right. So it's nothing glorified of what we're getting, and in conformity with what the regulations say we should be entitled to. All right. As far as the conditions inside the cell, all right, we're inside a cell with no property except a tablet. Now, let me explain to you how this tablet thing is. In the Cantel decision, that was one of the settlement agreements was about the tablet. All right, so that was a tablet program they were supposed to do. So that was the settlement that the Cantel case took. Instead of getting the TVs and the canteen and all that stuff put in there, they took this tablets as a settlement offer, and that a person should be in segregation no longer than 10 days. That was the Cantel settlement. All right, so that's how the tablets came into the process. So it's not like they willy-nilly gave this to us. And it doesn't, and the educational value of it is kind of low because it don't have that much on it, contrary to what he says. And we can't purchase anything on that educational tablet that they give us. The tablet that we have, our personal tablets that we pay for, is where we bought some of our games, we pay for our music, we stream the system. We used to be, you could buy your own music and all that stuff. Now it's a streaming system, they gave it to us. So we paid $13 every month for the streaming system in order to be able to access certain information on the tablet. It's the equivalent of having a radio. So now let me explain how that goes. If you got your tablet inside the hole, you cannot have your radio. They will not let you have both. All right. We can't have our TVs at all. We can't have our full property at all. We're given a very, very limited amount of property inside the cell. So we're sitting in a largely big cell with not much of anything. We're restricted. We can't have our headphones. that we pay for, the big headphones, they give us little tiny earbuds. This is what we're restricted to. We can't have our personal books, although we pay for it. They won't let us have it. They don't have a book cart inside the unit, all right, for us to look at any book. So we're literally looking at the wall 24 hours a day. And so let's talk about outside activities.
Yeah, I was about to ask you about that.
Okay, let's talk about outside activities. So when they tell them to get us to take us outside to the cell, they put us in handcuffs, 2-man escort. We get escorted out to the dog cage. It's like a dog cage. All right, we're with individual cages and we're separated from each other. All right, although we're supposed to be non-disciplined prisoners, administratively segregated. All right, and we're out there. Yep.
Is it true, Mr. Woolley said that though you're separated physically, there are other inmates you can converse with?
Yeah, well, there's cages. There's dog cages out there. So there's like 5 cages out there. So you got 5 people that come out there with you at the same time. It's just y'all separated from each other. So this is isolated and segregation. It's still segregated. It's not, we're not interacting. And that's what non-disciplined prisoners are permitted to socially, physically interact, not be kept apart in cages and partitions to keep us away from one another. So when we're out there for like 2 hours. That's what we're out there for, about like 2 hours. Then we go back to our cells. All right. So in this particular case, they got what they call table time. So only reason why guys over here don't do table time is for 2 reasons. First of all, if you try to do table time over here, the guys retaliate against you, tear your cell up and all that, because they don't want to go through the hassles of bringing you outside the cell and chaining you to the table. All right. So there's nobody doing table time in this BAU at all. And it's not being enforced because the guys don't want to do it. All right. Now, when you come out to go to the table, if you choose to do this, if this is going to happen, you get chained to a table. Your left hand and your right hand chained to the table. Your legs are in leg irons and it's chained to a pole under the table. You have no physical movement whatsoever. You're stuck in this position for however long you sat out there. This is not indoor recreation. This is not having the ability to move around and socialize or do anything. So if this is what somebody want to call recreation in a non-disciplined environment, then this is almost like putting lipstick on a pig and calling it a female. You know what I'm saying? Basically, that's what the DOC is trying to say in this regard. So what they're saying to you is this, in many words, they're saying, okay, we have laws that's in place that's telling us what we're required to do by the SJC, by the legislature and everything. However, we're operating on our own because even though the CGRA came down, we're saying, forget about the CGRA. We just created a new policy that's saying that we don't have to abide by that. That's not a statutory policy. As he sits there and tells you it's a statutory policy, that's not a statutory policy because statutory is the legislative intent.
Mr. Gaskins, this has been really, really helpful.
Yes.
But I am going to have to ask you to wrap up because.
Okay. So let me just say this. The stay that they're asking for is not justified at all because what they just admitted on this record is that they're violating our rights every day. They don't want to do the 90-day reviews. They don't let us attend these 60-day things in person. I just had one this past Friday. They wouldn't let me attend in person again. Although they just gave me a 90-day review. They just gave me one this past Friday, Patrice Hollomon, and wouldn't allow me to attend. And I said, I want to attend. And they said, no, we're not letting you attend. And they did it to me again. And I put on the paper, I wrote that I'm being denied to attend that hearing again. All right. So what we're entitled to and what the ask was in the lower court, which why Judge Frizz's order should stand, is because she complied with everything that Cantel and Haverty, Hoffa, and everything else says about how you are to treat non-disciplined prisoners. All right. The DOC is using as a pretext a name to change, to circumvent giving us those protections. They just admitted this right here in court just now. This was just an admission in this open record that they deliberately and intentionally circumventing the rules in the law. So they should not be granted a stay to continue violating the law when it's very clear on this record that we proved our case. We got the case law that backs us up on this whole entire thing from 1978 all the way up to 2016, the Cantel decision with the 2018 enactment of the CGRA, and then the recent decision under Perry versus Spencer, where this appeals, the First Circuit Court of Appeals agreed with everything that we said in Cantel, and how they believe that the 423s is what functions as segregation. That's what the First Circuit believed. But that's not, he just told you that's not the case here.
All right, that's, as the other said, it's been really helpful, but
Okay,
I've got
So-
several of your fellows to talk to, so.
okay, I'm sorry.
But
All right,
this has been really, really helpful.
okay.
Mr. Williams.
Yes, good morning, Your Honor. Well, you really touched on basically everything, but I do want to address some of the things that's in Patrice Hollomon's affidavit also. And
Please do.
on the third thing she stated in the affidavit, she said incarcerated individuals are not housed in BAU as punishment. To me, that kind of like, it really makes no sense, you know what I'm saying? Because me, I was put in the BAU from October 13th until basically February 9th or 10th or whatever, until I was classified to SAU 2, and I've been over there ever since. And I haven't picked up a D report ticket. I'm just told I'm pending investigation. I still don't have all my property. I'm in Tufts College program. I'm not able to attend Tufts College programs. I was in a computer lab program when I was loved. I haven't been able to attend computer lab programs. I was in 2 other programs that I haven't been able to go to. You know, and specifically, we're not able to attend these programs because the people that's running these programs are told not to let us attend these programs while we're in SAU or BAU, because they don't want us receiving good time while we're in these units, which is we're being punished in some way, shape, or form. You know, and yeah, so that's like another thing I wanted to address. You know, if we're not being punished, why am I not able to go to a college and receive my education? You know what I'm saying? And I don't have a ticket. I haven't picked up a ticket for 4 years, since August of 2020. So, you know, and I spoke to someone earlier this week in PLS named Bonnie about the SAU
Wait, hold on, what's PLS?
prison legal services.
Thank you.
And about the SAUs and, you know, the ongoing problems in all the SAUs because they're not being ran properly. And she asked me about my situation. I told her, you know, how I was in BAU and they classed me over to SAU and I don't have a ticket. And she said, it's not supposed to be like that. SAU is supposed to be, if you pick up a ticket, you lose your ticket and you get classified, you know what I'm saying, from the BAU to the SAU, because, you know, you're being held out of general population for X amount of months until they feel like you're able to go back to general population. Right now, they're weaponizing these units, the BAUs, the SAUs, and they're not really giving us any reasoning, you know, other than they say, oh, you're on pending investigation status, which I've been on for going on 6 months with no ticket, and I'm not being told anything. So obviously, this is some sort of punishment, you know what I'm saying, to be held out of general population for all this time, and I'm not able to receive certain things that I'm entitled to in general population. Another thing I wanted to address is the religious services. That's inaccurate. We're not able to attend any religious services in the BAU or the SAU.
Really?
No, yeah, we're not allowed to attend no services. In this building, there's 3 people that come in MCI Concord for religious services. The imam for all the Muslims, he doesn't even come to the SAU or the BAU. There's Deacon Tom and there's Pastor Dave. When you're in the BAU, they do around once a week, the deacons and the pastors, and they ask you if you want any reading material, and they'll give you a holy bread, daily bread if you say yeah. That's it. We're not allowed to attend no services. So in the affidavit, when she says we're allowed to attend services, that's not accurate. One of the deacons have several programs that he runs, and I was in those programs, anger strategies and anger and self-improvement. And when he did a round in the BAU, I asked him, what's going on with the programming, because before, several years ago, if he was in the BAU, if he was in the program, he would bring around a packet. You answer 10 to 15 questions in a packet, he'll come back in a couple of days and pick up the packet and to keep you enrolled in the program. He was told he couldn't do that no more because the program gives out a good time. And he says, until you reach general population, I have to terminate you from the program. That's all programming in the DOC. They don't let you stay in these programs while you're in BAU and SAU. They'll give you about a 2-week window to get back out into general population. And then if you're not let back out into general population, they terminate you and they put you to the back of the line. And you're not even able to get put back in line into these programs until you're in general population. So all the programs that I was in, I'm terminated from except Tufts. You know what I'm saying? And I can't even get back in line in these programs until I get back to general population when I don't even know.
I thought you weren't allowed to do Tufts either.
Yeah, I'm not. They don't let me go. But she's not, the lady Hillary, she's, in deep with the commissioner and the deputy commissioner. So she won't terminate you, you know what I'm saying, for going to the SAU.
She's not terminating you, but you're not able to do it.
No, I'm not even able to receive my books right now. They won't even let her come over and give me my books to study, you know what I'm saying? So she's like, she knows what's going on. Like, you don't have no ticket. They're not telling you nothing. They're not telling her nothing. And so until I get back to general population, I can't go to Tufts. And you know what I'm saying? Another thing, now I don't know, I've been out of the BAU for about 5 or 6 weeks now, is the book cart. When she says there's a book cart going around, the BAU, that's inaccurate. There hasn't been a book cart in that BAU for several years. You know what I'm saying? I don't know how long it's been, but the 4 months I was down there was no book cart that came around, not one time. So for her to say that's number 9 in her affidavit, for her to say the BAU is a book cart, that's not accurate. We have no book cart while we're in the BAU. So, yeah, the same thing he said, no contact visits, you know what I'm saying? Even the items that we are able to purchase while we're down there, they're not, they're the bottom of the barrel items. Like the toothpaste is, we're allowed to purchase the cheapest toothpaste, something called Freshman. The soap, we're not allowed to buy Dove soap in the BAU. They give us Next One. We're not allowed to buy the top of the line deodorant. They give us Power. They take the worst of everything and make it available to us, and then we're only able to buy $7.
Is that true in both BAU and SAU?
For SAU, it's a little bit more items on there. You're allowed to spend a little more, and they do expand it a little bit more, but we don't still have access to the same canteen as general population. And when I spoke to them about that, like, why can't we, they said, oh, because the SAU is equivalent to being in Sousa. So we try to base the recreation time and all that off of Sousa. Now, when I was in the BAU and when I'm in the SAU, I don't go to the yard because the yard, we don't have drinking water out there like in normal population. We don't even have the bathroom. Like normal population, they have urinals in the yard. You know what I'm saying? I have bladder issues. I use the bathroom a lot. So I can't even go to the yard in the SAU or the BAU because there's no toilet in either one. You know what I'm saying? So I'm not entitled to the same recreation that everyone else is entitled to. And other people, like Mr. Gaskins is on water pills. So he uses the bathroom a lot. You know what I'm saying? And once you're out there, you're out there because they really don't want to bring you out there. So even if you got to use the bathroom, they'll tell you, listen, do what you got to do. We're not bringing you back in. So you're stuck. You know what I'm saying? So I don't go to the yard as I would if I was in general population, because if I need to use the bathroom, I can go use the urinal, get water or whatever, so be it. But we're not afforded to that. It's put together so they say we offer you these things, but you don't take them because, just like the table time, there's going to be blowback if you take the table time, you know what I'm saying? Because they don't want to go through the process of strip searching you, linking you up to the table, then they got to strip search you before they put you back in the cell, and then, put you back in the cell. They don't want to go through all that process. So they say, listen, if you go, we're gonna tear your cell up. We're not gonna charge your tablet the way you want your tablet charged. We're not gonna give you the phone whenever you ask for, and situations like that. So that's really about it,
All right. This has been really, really helpful as well. Thank you very much.
But
Mr. Yardi.
Good afternoon, good morning. So basically, Your Honor, I like to say that I was in a situation where I had there's a lot of abuse of authority within the DOC, and I was in a situation where I was being threatened by IPS officers and stuff like that, specifically IPS Ayala and Lieutenant Breslin. And eventually, I didn't want to basically be an informant. I didn't want to be an informant. Shortly after that, I received a disciplinary ticket for introduction. After I beat the ticket, the first ticket, I was requesting to be shipped to another facility because clearly I have conflict with the two top IPS in Concord. And while I was waiting to hear what was going on, they were saying I was pending an investigation, et cetera, et cetera. And also these two individuals, I addressed PREA and staff misconduct issues, which they used the authority to basically oppress me in a sense. While I was waiting for that, they tried to force me out to general population back in Concord. And while they tried to force me out to general population back in Concord, shortly after the pending investigation, I received disciplinary infractions for that. And then shortly after that, I was given another ticket, a falsified ticket by Ayala, and another introduction, which is also them abusing their authority in the way, basically to oppress me in a sense. And due to everything Mr. Williams and Mr. Gaskins was addressing about the conditions and stuff like that, I had paid for an attorney to help me fight my ticket once more. But the conditions I was in were like so severe. I have my criminal conviction. I'm working on overturning my communication with my family, the canteen. The conditions are just so stressful that even though I had a lawyer to help me fight my ticket, I decided to plead out to the ticket just to avoid the conditions I was enduring at that time. At the same time, Your Honor, with respect to the court, Mr. Gaskin is very much more articulate, and I believe he had a lot more to say. And if I don't mind cutting my time short, because I kind of got my point across to an extent, to allow him to finish to elaborate some more of the stuff you have to say, if that's okay with the court.
Yeah, no, absolutely. If you're comfortable with what Mr. Gaskins, Mr. Williams has said, and it was quite articulate, that's fine. I won't.
Cool, thank you.
I will consider it all for everyone.
All right.
All right. That brings us to Mr. Hollomon. Sorry.
Thank you, Your Honor. Mike Worrell on behalf of Amicus Prisoners Legal Services. I want to be respectful of the court's time, so if there are particular areas that the court would like me to direct my comments to, I'm happy to do that. I think just as an overarching matter, it's our view that DOC's interpretation of the CJRA is incorrect because it's not possible for the legislature to have intended to allow DOC to hold people in conditions that are as or more restrictive than before the law was passed, while completely avoiding the law's reforms. The CJRA was a comprehensive remedial law intended to ameliorate some of the well-known harms of holding people in isolation by directing DOC to implement a number of reforms. Some of those we've heard about today, including procedural protections, minimal humane conditions, but there are others, including requiring specialized training and qualifications for DOC staff deployed in restrictive housing units, limiting placement of people with serious mental illness in restrictive housing, requiring specialized reentry programming for people in restrictive housing who are close to release in order to resocialize them to human contact and to reduce recidivism. But rather than implementing these reforms, DOC claims to have eliminated restrictive housing altogether because they hold people outside of their sleeping cells for 3 hours a day for what they euphemistically refer to as recreation. For people in the BAU, as you've heard today, the reality is that time is at least as confined in the time that they spend in the cells where they sleep. For the outdoor recreation, they're locked in a small cage alone. For the indoor recreation, they are shackled to the floor and to the table in incredibly restrictive conditions. And so we think reading the definition of restrictive housing, which refers to time confined in a cell, as excluding time confined into a chair or to a small cage, is inconsistent with the legislative intent, because that time is at least as restrictive in the time spent in the cell where the person sleeps.
I'm kind of surprised this is coming to me on a pro se complaint. Is there other complaints about these issues going on that you're aware of?
Your Honor, I'm not aware of another pending case that presents these issues. Certainly our office is looking at these issues, and I know other organizations are looking at them as well. So I wouldn't be surprised if it's presented, similar issues are presented in another matter, but I'm not aware of another one pending at the moment.
What do you think about I have trouble with the particular preliminary injunction here. It is rather vague as to what it requires. I mean, can you help me with this particular PI and understanding it, or maybe how it should be limited?
Sure, Your Honor. I think, reading between the lines of the preliminary injunction orders, it's clear that the Superior Court was frustrated by what it viewed as the Department of Corrections' attempt to work around the protections of the CJRA and intended to bring the department into compliance with the CJRA, at least preliminarily. So I think, its order clearly states that the 90-day hearings need to be happening for people who are held in segregated confinement. That it certainly, I think, applies to the BAU. The question of what other units may constitute segregated confinement, I think, is probably best left to the Superior Court in the first instance. It's hard on this record to say, categorically which other units those are. So that's how I would interpret the order there. There's also the issue of it orders, the immediate release of people pending these 90-day hearings. The department represented that, to its credit, it at least began conducting those hearings, though it hasn't released anyone back to the general population. It represented, I think, 5 weeks ago about that it expected to be done with the people in the BAU and the SAU in 4 to 6 weeks. That apparently still has not happened. So I think, the order had the effect of at least starting those hearings. You've heard from the department that if the order is stayed, that they plan to cease doing those hearings. And so that's one of the reasons we think it's imperative that at least that portion of the order is not stayed.
All right. Anything else you want to tell me?
No, Your Honor. I mean, I would point to, I think there are a number of different legal theories that would support the order and that have a good chance of likelihood of success. There is the application of the CJRA through the intent-based reading that, I just sort of outlined. There's also a more sort of strictly textual reading where you read the outdoor cage to being a cell. I think there are equally strong arguments under due process. The key cases there, of course, are LaChance and the recent Perry decision from the First Circuit as well.
There's a lot here. It just isn't very well connected with the injunction I've been given.
Sure, understood.
The problem I have here.
I can understand. I would submit that when you're looking at the likelihood of success of the merits, those alternative theories were pled in the complaint. They were argued at least in the papers at the lower court, and particularly if you're inclined to be lenient in the reading of pro se papers, though I think they were quite good. So I do think those are valid grounds for supporting the lower court's order here and finding that there is a likelihood of success of the merits.
All right, I would encourage you to stick with this case. I can't yet give you permission to be an amicus in the appeal because it hasn't been entered, though the transcripts have been ordered. I've checked for that and ordered in a timely manner. But I would encourage you to stick with the case. I can't imagine that you wouldn't be allowed to appear as amicus in the panel. Certainly you will be allowed to do that. I would encourage you to do that, and perhaps even keep an eye on the Superior Court case as well.
Thank you, Your Honor. Yeah, we hear you on that, and we certainly intend to be as useful as we can.
All right. Well, Mr. Woolley, the other side has gone quite a bit longer than I let you have. So out of fairness, I will give you a little rebuttal, just to even things out if you want it.
Your Honor, I would again just reiterate the factors that go into whether or not a temporary stay should be issued, and that's really the key issue here. Significantly, the substantial harm that the department would face, as opposed to the minimal harm that the plaintiffs would face, given that 2 of the 3 are already out of the BAU and a third is expected to be out of the BAU. I know there was a lot of discussion about the non-disciplinary housing aspect of it, and I will also note, and can certainly submit this as a supplemental filing to the court, but that the average length of stay in a department BAU is approximately 9 days across all incarcerated individuals. That's represented in the numbers that we submitted in our brief. The SAUs are designed to be more of a long-term program intervention that is designed to house individuals for a longer period of time. They're classified to those units and receive a great degree of due process during that classification hearing. They can also then appeal that classification hearing internally within the department and then to the Superior Court as well. With respect to the BAU, as of the early February numbers that the department gave, it was only approximately 18 out of, I believe, approximately 150 individuals.
Let me ask you this. If you were doing the LaChance hearings only for the BAUs, I assume you'd be able to do that with your staffing.
Your Honor, that would significantly reduce the number of required hearings, given that there are far less people in BAUs for more than 90 days, whereas SAUs are designed to house individuals for more than 90 days, and that's why they're there pursuant to a full classification board. So that would certainly reduce the number, but the efforts would still be duplicative with the 60-day appraisals, and the 60-day appraisals, the department again, sets forth are a sufficient level of due process given the conditions of confinement in department BAUs, namely the significant increase in outdoor and indoor recreation time, and et cetera, as I've already argued in my papers and during oral argument.
All right. So I'll expect by the end of the week, but earlier is better, that you'll give them a report on what happens with Mr. Gaskins' hearing one way or the other, or if for some reason it doesn't happen, then you'll let me know what the story is. And of course, Mr. Gaskins, you should feel free to do the same if you'd like to tell me how that went in your view as well.
Okay.
But I am interested on this hearing.
Okay. Can I just say something real quick before we close, Yana, if you don't mind?
Sure.
Okay.
One
One
of
of the things, we'll make it quick. One of the things is about a situation being repetitious yet evading review. All right. This matter is written all over it that this will be a repetitious matter yet evading review if this court do not lift this stay. All right, and don't allow them this temporary stay, because what they're just admitting on this record is that they are deliberately and intentionally violating what the SJC has said for years, what the Federal First Circuit Court just had came down and substantiated. And as far as Judge Frisen's order, it's not vague. It's just it was ordered in conditions in conformance with what the progeny cases said. When she said that anybody that's held without a hearing within 90 days or greater, without any hearing, she wants them released. That's what LaChance said. And when she said, until the outcome of this case, I want all benefits and rights and privileges restored to all people within the segregation units. All right, no matter what name you want to call it, which is the BAU or the SAU, because these are only two that exist. That's in conformance with what the law says. That's what 421 says. That's what Blaney says. That's what Hoffa says. That's what Cantel says. That's what LeChance did with procedures, but that's what Haverty says. All right. And so to say that it's vague, she may not have cited no case law, but it was pretty much she had the pleadings before her before she came to this conclusion. She had my injunction. She received it on January the 10th. So she had it for over almost a 30-day period. So she was able to research the law. So even if she didn't do that, her language is pretty consistent with what the law has already mandated that the DOC keep refusing to abide by. So she's pretty clear on it in that regard. And if you look at the language, you can easily connect the dots. It's not even that hard to connect the dots in this situation. What we're trying to do is stop the
You're very articulate, Mr. Gaskins, but you're definitely getting past the brief.
No, I'm sorry. So what this whole thing is about, Your Honor, is just to stop the injustice, stop the unfairness, stop the inhumane conditions that they've been allowed to get away with. The DOC been allowed to do this for over 30 years. And it's on record that it has to stop at some point. It can't just keep turning a blind eye to what they keep doing. And it's telling you right to your face that they're violating the law. They admit this on this open record. It's unreal that they even said it like that, but that's what they just did. Admit that they're violating the law. So that's all we're asking for, is because it's going to still play out in the lower courts, no matter how this slice. What is about, what conditions are you going to allow us to remain under while this thing plays out in the lower court? And that's what we're saying. It's not going to be a harm to them to give us all the stuff we're entitled to in segregation. It's not going to be a harm to them to release the guys who were not properly reviewed within a 90-day period. That's what the law mandates. That's what the SJC mandated. That's what was in the law since 2012. So they don't have qualified immunity. They can't even make that argument because it was clearly established at that time. So that's all we're asking for, Your Honor. We're asking for you not to allow this stay to continue because we are suffering. So even if I get out of here tomorrow, it's a good chance that I'll be put back in the hole.
No, I mean, this case will continue regardless, but I do want to, for balancing the harms, in the meantime, I need to know what's happening to the three of you as well as everyone else. But no, the case is not going to be moot tomorrow.
Yeah.
No matter what.
But what they're trying to make it appear like if you remove me from the equation, then you don't have to go forward with the injunction. Sure, because if you look at my history, I'm a prisoner advocate. They lock me up a lot. I get locked up a lot just because of my advocacy. So they could let me out tomorrow to appease the court, and then next week they put me right back in there and we start all over again. And then I come back and argue another case in the interest of the judicial economy, bringing more money to the Commonwealth to fight against this case.
I understand. Well, thank you. Thank all of you, both the attorneys and Mr. Gaskins, Mr. Williams, Mr. Yardi. This has been really, really helpful to me in understanding this case, which I was having quite a bit of difficulty understanding on the papers. So this was a lot longer than I expected, but has been extremely, extremely helpful to me, and I'm grateful to all of you. With that, we will end this hearing. I'd like to thank the clerk's office. I'd like to thank our clerk today who made this possible. I'd like to thank DOC for arranging the Zoom hearing, and court will be adjourned until Thursday, March 28th.